periods. Again, today's proceedings are being recorded for the public records. Please refrain from making any unnecessary noise. When testifying, please speak clearly into the microphone. When you begin, state your name and address for the record. Prior to approaching the microphone, you must be recognized by the board. Are there any further comments on the procedure from this council?
I'm sorry. Excuse me, Mr. Chairman, for the record, Ramon Rosas. I wanted to add and kind of add on to comments from the chairman. Based on the mandate from the Court of Special Appeals and then from the Circuit Court, today's decision will be based upon the record as it existed at the conclusion of the hearing in December of 2015. The board will not be taking additional evidence at this time, subject to motions by counsel. There will be exhibits introduced, I understand, but those exhibits will simply be extracts from the record that was generated previously. I anticipate we will only be swearing one witness. That witness will be Mr. Squires, who will introduce the records of said hearing into the record of today's hearing. Therefore, what I anticipate both the applicant, the opponent, and other comments will be comments directed to and commenting on the evidence as it was presented in the testimony in 2015. I'm sorry, counsel, I cut you off before you said something.
No, that was the clarification that I was looking for in terms of the scope of the court's reading.
Okay. Mr. Flynn?
I agree.
Okay. Thank you.
All right. Okay.
Should I swear Mr. Squires?
Yes, please. Is it the only one that's listed as a...
Well, he's the only one that's going to be presenting sworn evidence.
Okay. Very well. Go ahead.
Mr. Squires, if you'd raise your right hand, do you swear or affirm under the penalties of perjury to testify and present evidence that is the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Thank you, counsel. For the record, this is Board of Zoning Appeals case number 942-943, remand, October 9th, 2019. The exhibits for this case read as follows. Exhibit 224 is all the exhibits collectively that were done, executed when this original Board of Zoning Appeals hearing was conducted back fall, winter of calendar year 2015. And as it was returned to me from Circuit Court, and those documents were all organized, labeled, and behind the board for reference. There's only really 4 new additional exhibits that we're entering into the record. Exhibit 225 is the notification of the hearing of the attached distribution list dispatched to adjoining adjacent property owners by the Secretary of the Board. Exhibit 226, which is the notification of the hearing dispatched to the applicant by the Secretary of the Board. Exhibit 227 is the interoffice memo prepared by the Land Development Services Office and distributed to the necessary release agents, notifying them of this case, date, time, and requesting comment. And lastly, Exhibit 228 is the public notification dispatched to the Cumberland Times News for the purposes of notifying the general public of the hearing date, time, and location. And with that, concludes the exhibits for Board of Zoning Appeals case number 942-943, remanded.
Mr. Squires, I wanted to provide you an additional exhibit. This was emailed to my office. This is the letter from Mr. Flynn, who presents himself as the attorney for Anchor, interested party in this matter. We can mark this as an exhibit, but I believe the applicant does have an objection.
Okay, this is going to be noted as Exhibit 229 for the record.
Certainly have no objection to Mr. Flynn entering his appearance. I do believe that it's incumbent upon Mr. Flynn to identify whether he is representing Anchor, Inc., which is an entity, which is what is reflected in the entry of appearance, or if he is representing the individual members of Anchor. I raise the issue in respect to standing. There are people who are listed on the attachment to the exhibit who did not participate in the hearing in these proceedings in 2015. It is not clear, based on my recollection, whether Anchor itself actually participated in the hearing, so I need to note an objection to that extent.
Mr. Flynn?
Thank you. Good morning. And I haven't met everyone. My name is Paul Flynn. I'm an attorney based in Frederick. Thank you for having me this morning here.
Welcome.
In response to Mr. Getty's objection, my clients, to be specific, are the organization of Anchor, as well as Philip and Carolyn Bush, Mike and Kathy Rousseau. They are, the four of them, members of the organization, but they are also personally clients. To specifically answer Mr. Getty's question, Anchor is my client.
I would move to strike the portion of the admission listing the names of individual members of Anchor as not being in any way relevant based on Mr. Flynn's representation as to who it is that he's representing.
Well, there was an issue raised when I talked to council earlier this morning about standing, and whether or not that list was necessary to demonstrate standing from either party's perspective. If this matter were to go further, do you change your opinion from what we talked about earlier, Mr. Getty?
I do. I do not believe the exhibit can be attached because Mr.
The list of names is what we're talking about.
Okay. Mr. Flynn has clarified for the record the individuals who he represents, and the entity is not relevant as to the members of the entity because they can't leverage individual standing simply by membership in Anchor.
Mr. Flynn?
Well, I respectfully disagree, but perhaps Mr. Getty would waive his objection to standing, and then it's not an issue.
I'm assuming he's not going to do that at this stage. So the question, I guess, for the board is whether to admit simply the letter or the letter with its attachment that has the list of names. I think Mr. Getty's position is Mr. Flynn has identified 4 actual people who are affected so that the rest of the people are irrelevant, either for or against. I think Mr. Flynn feels that it's necessary for him necessary for the board and potentially whoever hears this case later to know who the members of Anchor Homes are. I keep saying Anchor Homes, I apologize, because that's the construction company that built my house. But Anchor, who the members of Anchor are, to determine whether Anchor has an interest in this hearing. I think my suggestion would be, since the board isn't going to be really considering the names on the list at this stage, I don't think it's a problem admitting the list, but I would, of course, leave it to your discretion.
I agree. Admit the list? Yes. Okay, we will admit the list.
Okay. Any other evidentiary issues before we begin the applicant's presentation?
So the only people who will speak today are both attorneys. There's no other list.
No one has signed up
Signed up.
to address the board?
Besides parties? Mrs. Squires?
Let me ask the audience, has anyone signed up to speak, to address the board? One gentleman here. And would you be speaking for or against, sir? Just so I know where to put you in the lineup. Undecided.
I'm kind of neutral.
A question, do you have for or against the question?
Question.
Okay. All right, well, then you'll probably be going last, sir, just so you know.
All right. Okay, now this gentleman has to be sworn in for a question.
Well, no, because he's not going to be, because again, there's no
Wonderful.
evidence
Just want to
presented
make
at
sure.
this point.
Thank you.
Yeah.
Okay.
Are we ready, gentlemen?
Ready?
Members-
Mr. Getty, go ahead.
members of-
Mr. Getty, do you need the lights turned down?
If the board members can see what's on the screen, and those in attendance can, we're fine. Members of the board, my name is Gorman Getty. I represented the applicant, Dan's Mountain Windforce, in the hearings in 2015 through the circuit court, through the Court of Special Appeals, and now in the remand to this board. I am here today with David Friend, who is seated with me, as well as Matt Brewer, each of whom spoke and testified at the hearings in 2015. At the outset, I appreciate Mr. Rosas' review of the manner in which today's proceeding will go. I am ever mindful when dealing with the courts of the limitations that the courts have placed on parties in litigation, or parties, in this case, in a matter before the Board of Appeals. The court has essentially closed the record for the purposes of your consideration of the information and material that was presented to the Board of Appeals in 2015. In doing that, the court has provided instructions to you, has provided guidance in the methodology that is to be followed, and has impressed upon all of us the issues that should be taken into consideration by the board. In making a presentation today, it is not my intent, and I hope that I have scrupulously followed the edicts of the court. It is not my intent to introduce any new evidence. In what I will say to you, in the presentation that I will make to you, I am providing you with citations to the record itself, to the transcript of testimony, to exhibits that were admitted. It is in the nature of argument. I am urging you in the context of the presentation that I'm making, as I did in 2015, to consider favorably the application that's been made by Dan's Mountain Windforce for the approval of the wind energy system on Dan's Mountain. So I have done this in the context of a PowerPoint presentation, number one, to limit my time and to try to provide some focus to these proceedings. A little bit of the history of the proceedings, just to review again what the nature of the application is. These are proceedings for a proposal to construct and operate a 37.57 megawatt wind energy project near the town of Midland in Allegheny County. For purposes of my presentation, I'm simply referring to it as the project. You'll see at the end of that very first sentence a parenthetical T-102. That is simply a reference to that statement in the transcript of the record, and that is what will follow each of the statements that I am attempting to point out to you in this presentation. The project itself, as proposed, includes 17 utility-scale turbines and electrical substations, which are to be constructed on the westerly facing slope of Dan's Mountain, and involves some 2,900 acres, which is roughly 4.5 square miles. The applicants for the project are comprised of Dan's Mountain Windforce LLC, which the record reflects is a wholly owned subsidiary of Laurel Renewable Partners. And the applicants are also comprised of approximately 25 individuals who are the owners of the project site itself. Now, industrial wind energy conversion systems, windmills, in Allegheny County are regulated by the county code. The specific reference is 360-92. A windmill and this particular undertaking is permitted within the agricultural, the A district, and the conservation C district by those specific provisions of the code. But in that permission, it is subject to approval of the board as a special exception. The applicants in this case, Dan's Mountain and the individuals, filed a petition for special exception under the zoning regulations, which we simply refer to as the petition. And that petition is designated as case number 942. The variances are a separate component of this land use application, and variances from the terms of the code provision for windmills by the provisions of the code themselves, require written authorization of all property owners within a prescribed separation area. And we're simply referring to those as the separation variances. That reference appears at section 360-92A8 of the ordinance. And written authorization of all affected property owners from the prescribed setback lines. And they are the setback variances. You will hear as we walk through, and you are undoubtedly already aware by your review of the record, that there are in exhibit, which is referenced there as L1, which is, there is L1 and K. They are the separation variances as well as the special exception. Within those particular documents and exhibits, there are panels, there are sheets which show each of the properties and each of the variances that are being requested. The setback variances are for a number of the windmill towers. We know from the Court of Appeals that we are judging those setback variance requests from the location of the towers themselves, which is part of the evidence that we presented in 2015. When in the process of these applications, we are talking about a variance, it is styled as an appeal for a variance under the zoning ordinance. And those have in fact been filed by the applicant for both separation variances as well as setback variances. I want to begin with the petition for special exception, which is case 942. In Allegheny County, a special exception is a land use that is subject to your review and approval. At the hearings that were scheduled in 2015, October through December, the petitioners offered evidence and presented testimony that came from David Friend as the managing member of Laurel Renewable Partners, LLC, as well as expert testimony through witnesses Matt Brewer, Richard Josephson, Sean Davis, and Robert Miller, all in support of their petition. Behind each of the names that are there on the panel, and I will provide the board with copies of these panels and these references, but it shows the testimony through the transcript for each of those people. For example, with David Friend, his testimony appeared at the transcript pages 33 through 89. Matt Brewer, as you can tell, testified for an extended period of time, beginning at page 95 and ending at page 369. Richard Josephson, 370 to 439, Sean Davis, 439 to 471, and Robert Miller, 47, it should be 447, I believe, through 352. So what did the evidence that was presented, what does that reflect? As to David Friend, he testified and identified what Laurel is. Laurel, along with the owners of the project site, are the people who authored the petitions and seek the variances. He testified that it is their object and their intent to fully comply with the requirements of section 360-92 of the code. That testimony again appears at page 43 of the transcript. Mr. Friend testified that if approved, the project would have a construction price of between $90 and $100 million and would generate tax revenues for the county in the range of $1 million a year. Again, at transcript page 44. Mr. Brewer, who is here and seated at council tables this morning, is a principal with Bennett Brewer and Associates. At the hearings, he offered testimony as an expert in land planning, engineering, and he is a registered property line surveyor. That appears at transcript page 99. Mr. Brewer testified that he has worked on wind energy projects in Maryland, Pennsylvania, West Virginia, Texas, Montana, and Michigan. And of the 4 wind farms constructed in Maryland as of the time of his testimony, Mr. Brewer had designed, permitted, and built 3 of them. Mr. Brewer, in the course of his testimony, reviewed the petition line by line. In particular, to understand what Mr. Brewer did in the application for both the special exception and the variance. In particular, the relief sought, and the 2 properties are a U.S. Cellular property and a state of Maryland property, but the relief sought in respect to the U.S. Cellular parcel was Mr. Brewer's testimony that it was required by a coalition of factors that he described, and in the same factors that dealt with the location of the towers for the separation variances applied to the setback variances. And he testified that as to the state of Maryland property, that setback was required by the same factors that were associated with the Sesnick property, which was part of his overall testimony. Again, there was no testimony from anyone at the hearing opposing appellant's evidence on these variances. So that is, in brief summary, synthesizing days of testimony, what we believe the evidence demonstrates. That the applicant has satisfied the special exception requirements and the variance requirements that are a part of the code. But we are here because the court has remanded this matter to this board. And I think it's necessary that we look at and talk about the Court of Special Appeals decision. To go back to the original board's decision, the board initially denied the variances because it did not think the co-applicants' properties were different from each other. The Court of Special Appeals made clear that it is not a comparison of co-applicants' property that is required. Rather, that it is an appreciation of other properties' usual characteristics with any unique features of the applicant's property, and whether there's a nexus between those unique features and the provisions of the zoning ordinance that impact the applicant's property, such as separation or setback, disproportionately. The court observed that the code establishes restricted areas that are within a certain distance of a host property boundary lines, which are simply setbacks, or within a certain distance of a building on adjoining property, such as the separation distance. The court observed that the code allows for a variance to permit a structure within those restricted areas with the consent of the owner, who is the affected property owner. Each of the variances requested requires, as described by the court, an analysis that while looking at the property where the structure is to be placed, not looking at the property which is being impacted, not looking at the residence, we're looking at the tower sites for that purpose. And the court, in its analysis, lays out questions which are, I believe, designed to enable the board to consider what it is the court is talking about in conducting an analysis, in making its findings, and in writing an opinion. And the court asks those questions, and some of those are here. What are the factors that preclude the placement of a structure on the property outside of the restricted areas? Are there unusual factors identified by the applicant? Features of the property on which the structure is to be placed? Does the effect of those features or those factors taken together have a nexus, have a relationship with separation and setback provisions of the zoning ordinance? Is the existence of those features the reason why the structure must be placed within the restricted area? Is the effect of those factors, those features, on the property unique as compared to similarly situated properties? Does that uniqueness of the property where the structure is to be located cause the zoning provisions to impact disproportionately on that property resulting in practical difficulty to the applicant. Are there features on the applicant's property that cause the separation and setback requirements to affect the property differently from the way it affects other surrounding property? That's what the court talked about, thought about, and has asked you to think about as you consider the application. And if we turn those questions to the evidence that was produced before the board, we're then caused to ask, what are the features? In this particular case, what the applicant identified through its testimony and through its evidence are specific features of the properties where the towers are to be located that generate the basis of the variance request. That evidence shows that it was dictated by the concepts of environmental site design, the microwave beam paths themselves, logging and deforestation, mining activity, both surface and deep mining, topography of the property, jurisdictional wetlands, wood rat habitat, black-fruited mountain rice. What is significant is that's a list. To get to that list, what the applicant did and what the testimony reflects is that Mr. Brewer utilized all of his skill and the dictates of environmental site design in approaching how to utilize this particular property. At incredible cost, Mr. Miller undertook an analysis of the microwave beam paths and generated a report of hundreds of pages, which even at hundreds of pages belies the amount of time and effort that was necessary to identify what those factors are. For the logging and deforestation, that is a historic aspect of this property about which Mr. Brewer provided testimony. The applicant hired Dr. Liu, and this is part of the testimony, from WVU, to do a study of this property. And Dr. Liu's evaluation was testified to by Mr. Brewer, and a map showing the prior deep mine works and an overlay of surface mining were part of the record. The topography of the property, how the property lays, is depicted on almost every exhibit that has been introduced by the applicant because it shows ground contours. It shows the elevation of the property. It shows, and the testimony was, that towers need to be located so as to receive favorably the wind. The testimony that is there demonstrates that studies were done to ensure that the appropriate agencies were consulted about the presence or absence of jurisdictional wetlands, that public agencies were sought, information was sought from them concerning the wood rat habitat and the black-fruited mountain rice. None of those elements standing alone is being presented to the board or was presented to the board as just, these are things we have to think about. Each one of those was studied. Each one of those was developed because they were unique features on the property. And as Mr. Brewer testified, both in respect to the special exception and in respect to the variances, these were constraints on the property that had to be dealt with in order to utilize the 4.5 square miles of the project site. In particular, and I can't emphasize this more strongly, the Court of Appeals did something in this case that it wasn't obligated to do, but it exposed and represented to this board its conclusion that the evidence that had been presented was legally sufficient to support the variances, but that it was for the board in the first instance, the board's role and not the court, to make that initial analysis that it outlined and to determine whether the variances were appropriate. And that is a quotation from the court. The court stated, "It is clear that Windforce adduced evidence of several factors on each of the co-applicants' property that suggest that the separation and setback requirements operate differently on each of the properties than they operate on other surrounding properties." That's the question. That is the issue. And the court has concluded for you. That's its observation. What the court said, though, is we decline, however, to rule on the merits of those arguments because the task is for the board in the first instance. And it is remanded to you so that you can do that. So the question becomes, when do you get a variance? We suggest to you that the court has instructed this board and all of us that variances are granted when the uniqueness of a property is not shared by neighboring properties and the uniqueness of the applicant's property results in an extraordinary impact on it by operation of the statute. The court says, where because of the narrowness, shallowness, unusual shape, topographical conditions, extraordinary situations, or special conditions, the literal enforcement would make it exceptionally difficult to comply. That's when you get a variance. So what is the evidence that the Court of Appeals was able to find in support of the variance request? The evidence they had is the evidence that is available to you. It is the record of the hearing held in October of 2015 and then continued into December of 2015. It is that record that makes it clear that Windforce adduced evidence of several features of each of the co-applicants' property that suggests that the separation and setback requirements operate differently on each of those properties than they operated on surrounding properties. So what is that evidence? I have for you, and I will give you the panels that are here as a part of our presentation. But if we go through the elements that the witnesses testified to, the requirements of environmental site design, those are the citations to the pages in the record that show how they impact on the property and impose limitations. Jurisdictional wetlands, those are the citations to the record as to how jurisdictional wetlands apply to the property. Deep mining and surface mining, you will see in the exhibit that Dr. Liu produced and in the testimony that was presented, how that impacts on the property. There are also technical requirements of the turbines, and those are the citations to the record and the description of Mr. Brewer's testimony relating to the fact that they were fixed constants in his analysis. The communication beam paths, those are the citations to the record. Wood rat habitat, black-fruited mountain rice habitat, and topography of the property. We have taken the time to give you those citations because this record is substantial, and we appreciate that. So the question becomes, when you apply the features that the court acknowledged, when you apply those features to the applicant's property, what's the result? Is there a narrowness, a shallowness, an unusual shape, or are there topographical conditions or extraordinary situations or special conditions that exist on the property that would make it exceptionally difficult to comply with the literal enforcement of the separation and setback requirements of the code? The answer from my perspective is to ask you to see for yourself. What this is a demonstrative exhibit which is based entirely upon evidence in the record of these proceedings. There is, which you cannot see, and I apologize for that, but there is a legend associated with this depiction. But what is significant is to understand that the unique features and factors that exist on the applicant's property are all of the colored areas that you see. So when you see, for example, the brown, if you can, no, you can't do it.
Mr.
In the
Giddey,
upper,
I hate to interrupt you, I apologize. Is this part of the record, sir?
it is, everything that is on this is part of the record.
But is this depiction part of the record?
This is a demonstrative exhibit to outline the presentation we're making. It
I have
is
objection
based-
to its use.
It is based upon and is a part of everything that is on that is in the record of these proceedings.
If I, just to follow up on that, so I understand what you're saying is that the notations that you or your assistant put on this were extracted all from the record, and that were we to go back and review each one, they'd be based on some
There is-
testimony or document?
The base for this is Exhibit KA1, which is a map, which has the contours. The Mertens map, the brown at the top of it is a specific exhibit. The areas in terms of the setbacks are all depicted on Exhibits A1 through A8. And the beam pass appears at the EIA, page 22.
So these are overlays of
These are
those
just
maps that you
overlays
cited?
of maps and exhibits in evidence.
Was there a question that you wanted to ask? I'm sorry.
Well, what we see here, Mr. Getty, is basically a synopsis
That's
of
all
what's
it is.
happened in the past.
Just
So it has
graphic
been-
representation.
Right, and
That's
we've seen so far all the written detail of that.
Correct.
And this is the first visual depiction of the same thing, am I correct in
That's
assuming
exactly
that?
right. Yes.
Do you have anything you want to add, Mr. Flynn?
I would like to maintain my objection for the record and only add that this is not evidence.
Understood.
Because there is no new evidence today.
Well, and let's address that. One of the things that lawyers know is that when they stand someplace like this, that there is a caveat to anything we do or say. What I say is not evidence. That is true in any presentation like this. If I'm talking to a jury in a case, if I'm talking to a court, what I say is not evidence. What I am doing is simply presenting my view on behalf of my client's view of what that evidence depicts. And this is simply demonstrative of what that evidence is. It is not evidence. It is simply my attempt to graphically depict and point out for you what I believe the evidence demonstrates.
My recommendation would be to accept the exhibit purely as a demonstration, not, of course, as evidence. If the board would like to look at the evidence that is based on the map, that the map is based on, excuse me, I believe Mr. Getty has identified the actual maps as evidence that you can review.
For purposes of this demonstrative representation,
Is this I'm sorry,
Go
Mr.
ahead.
Getty. Is this a physical exhibit that you're going to be giving to the board?
I have the panels. I'm going to give the board for their consideration. to the
I guess
extent
my
that-
question is there a larger version
Nope,
of this?
it's a small version.
Okay, all right.
Because I'm just doing it off the presentation.
Understood.
But for purposes of understanding what's being depicted there, what I had said was essentially it's only the white areas, the uncolored areas, where you can put the windmills. That's what Mr. Brewer's testimony was in respect to the exhibits as we went through them at the hearing. At the top portion of that, you can see a brown coloring. They are the mines, the Mertens mines that Dr. Liu testified to and that he delineated. You can see circles around, and again, this is at some distance, but they are actually the location of the wind turbines as depicted. They are also part of the exhibits associated with the variance requests, A through A10 total. The red area is the property line setbacks. That's what the code requires as the property line setbacks for wind energy conversion systems. Blue is the residential setbacks. Green is the environmental or cultural resources. When we're talking about the habitats that are there, the green is how they are depicted on it. There are steep slope limitations, which Mr. Brewer testified to. That is slopes 20% or greater. They are yellow. There is purple, which is existing residential properties, and you see those internal to the property itself. And the black is the microwave beam pass depicted in 2 dimensions, not 3. I did this exhibit, or I had, to be honest, had Mr. Brewer do this exhibit, because it is in fact difficult for most of us to conceptualize through separate exhibits how it is those factors that the court found had been sufficiently identified impact on the applicant's property, and in particular impact upon its location of windmills on its property. The effect of the limitations, whether it is the red setbacks or the blue residential or the habitat or the purple of the existing residences or the beam paths themselves, you can see there aren't lots of locations in which these towers can be located. There is a practical hardship dictated by the confluence of all of those factors that, as Mr. Brewer testified, dictated how and where the towers were located. He testified that they went through more than 25 iterations of tower locations to accommodate the physical limitations and conditions on this property. It is those physical features, those unique features, and in particular, please understand, there is no evidence before this board that these features are shared by other property. That may have been the opponent's opportunity to do, but they didn't do that. What we were able to show and what the court was able to conclude is that we were able to demonstrate to the satisfaction of the court that there are features on this property not shared by others. And that's the satisfaction of the requirement for the variance. So what we are asking this board to do, in consideration on remand, is to rely on the evidence that has been presented and to grant the relief that is being requested. There is no evidence, we suggest, that would warrant a denial of the special exception in case 942. The impact on this property at this location there is no evidence that it is enhanced or varies, and it satisfies the requirements of Schultz v. Prince. And in this particular case, the confluence of all of the factors that the court identified, that Mr. Brewer identified, and that I've briefly gone through today, coalesce to demonstrate that the variance request is appropriate in these circumstances. Now, I have for the board, again, just for demonstrative purposes, as a summary of my presentation, the PowerPoint presentation is here. And I also have, for the board's consideration, as a separate exhibit, not really an exhibit, I'm offering it as an aid to the board, and would ask that they consider, for each of the wind turbines, we have identified the requirements that are a part of the code, the testimony and the citation to the testimony that we believe supports findings to generate and permit granting of a variance. The court was clear that it's imposing on you a significant exercise to go through each of the variances that relate to the property. We offer this in terms of a listing of citations simply as an aid to that, nothing more.
Mr. Flynn, have you had an opportunity to look at this?
No, sir.
Could we just give Mr. Flynn a second to look at it? Thank you. Mr. Walters, I thought this was, I'm assuming he's wrapping up now. Do you gentlemen have questions you want to ask him? I just have a few, but I figured I'd go last if you guys want to go first.
that's the presentation.
Oh, this is just the PowerPoint.
That's just the
Okay,
PowerPoint.
sorry.
I have, still holding.
Thank you. Mr. Flynn, do you have a position on that demonstrative exhibit?
I have no objection to the exhibit that Mr. Getty just showed me. It's a multiple-page list of citations to the record. I have no objection to that. My only objection to what he's proposing to hand up is to the extent that the depiction that I've already objected to is included there, and I'm just noting that for the record.
Okay, so you're objecting to the board receiving the PowerPoint presentation, which has that map in it that we
Because it has
discussed?
that map in it. Yes.
Understood.
I would certainly recommend that, understanding Mr. Flynn's objection as to the PowerPoint, you've already ruled to that, and he has no objection to that exhibit, so I think we should take both of them.
Okay. Thank you. They're both accepted, yes.
And with those, we thank the board for their attention and their time this morning.
Did you, Jen, have questions?
Yes.
Mr. Getty,
could I
I
ask a
think the
question?
board may have some questions for you.
In the code, 3 is now a different number, 36107, by the way. It's just a different paging. No changes have been made to the code, especially pursuing this application. Under F1, it makes a provision for applicants submitting for review a certificate by a qualified engineer attesting to the structural integrity of each windmill, and a wind's load analysis prepared by a qualified engineer may be eligible for an administrative adjustment of up to 25% of the required setbacks as specified in subsection B herein. I was wondering if the applicant has tried to pursue that.
We will, in order to answer that question, I end up outside of the record of these proceedings.
Okay.
Can we simply say that the evidence there's no evidence of that application?
Yes. I mean,
If that's the fact.
I mean,
Yeah.
the answer is yes to the question, but it was not part of these proceedings.
Okay.
Okay.
Okay, thank you.
The follow-up question, I think, and something that a follow-up question would be, to the extent that the code has specifically authorized a setback variation when there's a certificate of safety,
Right.
does the lack of a certificate of safety in the evidence affect the setback application in your opinion?
No, not at all.
Okay.
No.
Could you expound on that? Why?
Well, I mean, the simple answer is all of the structures are certified by engineers, you know, in the course of design and construction. There was getting outside the record, a decision was made. I can tell you, I've got copies of the sealed plans that say, you know, everything's fine, from engineers qualified and registered in the state of Maryland.
So that they
We
meet,
simply didn't choose to do that as a part of this application.
and you don't believe that that has any,
The same standards apply.
yeah.
I mean, without regard to that provision of the ordinance, I understand why it's there. It allows the applicant to take advantage of something. Applicant doesn't have to, but the standard's still the same. When we build the structure, we still have to have certifications from engineers as to the safety of the structure. But for reasons unrelated to safety, you know, that decision was not made, you know, was made not to pursue that. We're not asking for anything more. We're trying to comply with everything that the ordinance says.
Does that answer your question, Mr. Walters?
Yes, it does. Thank you.
Does anyone else have any questions? I just have, I think, two. Am I correct in understanding that all of the currently existing homes that are within the setback or separation variance requests are co-applicants?
They are.
Okay.
Now, I will point out, and I'm sure that Mr. Flynn will point out, that one of the co-applicants, his property is subject to...
Do you want to bring that up now? Because I
Well, I
understand
think I
there's an
have to in
objection
order to
about that. Okay.
answer your question.
All right.
There is one property that has changed hands. that property owner is subject to all the agreements that the prior owner placed on the property.
And I'll just briefly put that on the record, and you can address it in your presentation. My understanding, an issue that was brought up is that one of the homeowners, and I don't know which one, that originally was co-applicant and signed an easement, has sold his property to someone else. That person now, personally, I do not believe is a co-applicant and may or may not support the project. However, the easement is still legally binding on his property, so there's a little dispute about whether that's relevant or not.
Thank you.
Thank you. I don't want to cut you short for lunch or anything. Do you think you have enough time, Mr. Flynn?
If the board is willing to sit, I don't know if anybody needs a break.
Well, I'd like to do about a 5-minute break right now, a 5-minute recess. All right, thank you.
Thank you.
Thank you.
And we'll reconvene about 10 minutes past 11. Is council ready?
Sir.
Yeah.
I don't need from zero to somewhere in the back.
So when you're done with them, you say it to them, I'll take these back.
So these you want, that you realize you want back.
Yes.
I'll bring
And then, that way, if you gentlemen begin this stuff, they can break your numbers down. Because I'm sure that they'll come.
Yes, I've got it. Got it. Thank you.
Is there anyone else that wanted to sign on to speak?
So there are at least 2 or 3 people who late, I don't know if they were latecomers or they're here that didn't sign up but haven't said they want to have now during the break signed up to speak. That's up to you whether you want to let them sign up. Okay. Yeah. I don't know if you want to take them. First thing you have to decide, do you want to take them? They're technically late, but if you're assuming you're willing to take them, if they're for, they should probably go now. If they're against, we'll wait till after Mr. Flynn. Do it now. I think we absolutely should take them.
That's fine, yeah. No, absolutely.
Just going in the process, all the 4 people, and all the against people, and
Okay.
city people.
That's fine. Absolutely.
I'll do whatever, thank you.
Okay. Okay, the hearing is back in session. At this moment, I'd like to open the floor to other people who are for and support the applicants. Is there anybody who wants to speak in support of the application? No? In that case, Mr. Flynn?
Thank you. For the record, my name is Paul Flynn. It's my privilege to represent the Allegheny Neighbors and Citizens for Homeowners Rights Limited, which is known as Anchor, as well as the Bush family and the Rousseau family who are seated at the back. Darlene and Bill Park, seated at my right, are representatives of the organization. Before I get into my planned remarks, I wanted to address something that was part of Mr. Getty's presentation. Twice the board was shown a quotation on the screen from the Court of Special Appeals. And the suggestion was made that these 3 gentlemen in Annapolis, who have never seen Kensington, had somehow concluded for this board that criteria were met based on evidence in the record. There's a concept called dicta in law, and I know Mr. Getty would never suggest to this board that the panel of the Court of Special Appeals could essentially do this board's job for it. I don't believe he meant to imply that. But I want to make it clear that it is this board's job to evaluate the evidence and to answer the questions. The Court of Special Appeals' job was to define those questions, and there should be no confusion about that. I'd like to try to do 5 things if I could. I want to try to show first that these variance applications have failed the very most fundamental task for any variance application. That's show me the property. That's 1. 2, I want to try to establish that for the life of this case, up until I believe this morning, the zoning merger doctrine was a crutch upon which the entire case for this variance or these variances rested. But we heard nothing about that this morning. 3rd, the evidence in the record flunks Court of Special Appeals uniqueness test. 4th, I'm going to show you that there is no evidence for practical difficulty in this record. In fact, the only evidence is that there is a problem of the applicant's own making, and that is trying to cram more of these turbines onto these properties than fit. And 5th, I want to try to dispel this myth about these variances being from the applicants and for the applicants. It's a very unusual situation in terms of zoning and variances, and I want to try to clarify what we're really talking about. So those are the 5 things I want to try to accomplish, and hopefully I won't wander around too much in trying to do it. Primarily, we're here to correct what the Court of Special Appeals has said went wrong the first time here. And I wasn't here the first time, and I think perhaps not all of you were here the first time, and so I think it's beholden on us to try to identify what exactly went wrong the first time. And I want to start by reading from the 8th page of the Court of Special Appeals opinion. They wrote, "It, with reference to this board, did not take into consideration the particular effects that each of Windforce's listed factors had on the placement of turbines on each particular property, or how each factor affected each property differently. As we shall discuss, the correct test requires the board to look at each of the factors identified by an applicant as making the property unique and determine whether those factors together affect each property." It's intuitive. It's a simple starting point, which somehow has been missed here. The analysis needs to work from the property where the non-conforming turbine would be built. The analysis should be, here's the property, here is the characteristics, and these characteristics meet the uniqueness standard because of these reasons. That's consistent with the county code. The zoning variance is defined in section 360-59 as a change of density, bulk, or area requirement with respect to the location of a building or use on a lot of record, where the physical or natural character of the lot would otherwise preclude the use of the lot. It's also no doubt consistent with this board's common experience, that when your neighbor wants to build a shed too close to his property line, he must describe to the board his property and why the attributes of his property require the variance that he has requested. This was the essential error of 2015, was not to study the parcel where the turbine will be built first. And I think what we've seen here today demonstrates through Mr. Getty's excellent presentation that that mistake would be propagated again by this applicant. Here's how the analysis should have gone. And I'm not a surveyor, but as far as I can tell from my review of the record, this is what should have happened. The applicant should come in and say, we'd like to build turbines 12 through 17 on parcel 92. It's a tax map reference. That belongs to Leslie Forsyth, Marcine, and Cindy Bow-Trustee. That's at least how the maps indicate. I'm going to refer to that as the Baugh Trust, it's parcel 92, which is 1,700 acres. Then they should have said, here are the unique physical and natural characteristics of those 1,700 acres. Then, here are how those characteristics connect with the variances that we're requesting. This is why those physical characteristics of that 1,700 acres requires this variance. That's the connection, that's the nexus the Court of Special Appeals says we have to have. And then lastly, here's the evidence that those characteristics are unique to those 1,700 acres, to that property where the non-conforming turbine would be built. Then they should have come and said, well, we'd also like to build turbines 6 through 9 and 11 on parcel 83. That's a tax map reference belonging to Dan's Mountain Sportsman's Club, as best that I can tell from the record, which is 713 acres. And the same information should have been presented about that property. Lastly, they are proposing, as far as I can tell, to build turbine 5, also non-compliant with the law, on the lower property, parcel 29, which is 129 acres. Now, the board could be forgiven if it didn't discern that information from either the presentation this morning or from the record. It is in there, that's where I pulled it out of, but it took a little time. It's a simple proposition. Now compare this to what the applicants actually presented, and you'll see that they never got past the starting line. Where in this record do we have a description of any of those 3 properties? Now, I'll be the first to admit, there's a lot of paper here. Maybe I missed it. But I didn't see a single parcel, a single plat, which shows all of any of those 3 properties. How can we grant a variance if we don't even understand the property to which you would apply? It's just basic, very simple. Here's what they did instead. From the beginning of this process until this morning, they have built this case on a zoning merger doctrine, which suggests, and they have argued both here and at the Circuit Court for Allegheny County and in Annapolis, that this doctrine of law permits them to treat these multiple properties as though they are one property, and they are not. This has been rejected first by this board. It was rejected by Judge Finan in the Circuit Court, and though less than definitively, it was rejected by the Court of Special Appeals. And I say less than definitively because they left the door open such that Windforce could come in this morning and continue to advocate for the adoption of the zoning merger doctrine. Now, they have not done that explicitly. Now, I want to read from Judge Finan's opinion.
I'm going to object to any recitation of Finance.
I believe that's in the record.
It is in the record. I think whether it controls in this case or not is disputable because there's a decision reversing him. I think my suggestion is it's okay for him to read that because it's in the record, but I don't know that it should guide you in any way. Do you understand what I'm saying?
From the obviously it's after the evidentiary.
It is after the evidentiary hearing. I guess it's technically part of the record in that it was a decision by a court above the zoning board. If I understand Mr. Getty's argument, he's saying that that decision can't bind you in any way because it, in fact, was reversed by the Court of Special Appeals. Mr. Flynn is saying that it's a part of it, so he can talk about it to you. I guess I tend to agree with him that he can talk about it, but as Mr. Getty points out, that decision not binding on you in any way because it was reversed. That's my advice.
Brian, you have an opinion on that? I agree with that. No problem.
I think you can go ahead.
And I'm not sure if I'm officially supposed to be able to hear Mr. Rosas or not when he's talking to you.
These
but
things are always very weird. I don't know.
It's over.
I actually agree with what he just said. I'm not reading this to suggest that this is binding law. I'm reading this to demonstrate a point as to the way the applicant has characterized this application throughout the process until this morning. On page 3 of his opinion, Judge Finan wrote, "Here the zoning board considered Windforce's expert testimony and found it lacking with respect to proving the uniqueness of any of the co-applicants' property. Windforce and the co-petitioners seek to avoid the consequences of being unable to show difficulties or hardships peculiar to the properties in question by arguing the parcels are all one for zoning setback purposes." Now, because you were paying close attention to Mr. Getty's presentation, you no doubt noticed that while he hasn't said this board should adopt the zoning merger doctrine, the entire presentation is still premised on that concept. Take, for example, the color depiction that I objected to. All right, it's been handed to you as part of the presentation. It's before you over my objection. All right? That depiction would be relevant. It would be very relevant if the outlines of that drawing were a property, or a parcel, or a property, or a lot. It is none of those things. The outlines of that drawing combine, I don't even know how many properties, probably hundreds. Hundreds of properties. I shouldn't say that because I don't really know, but it's not a property. Right? And what you can see from not only the map that was, that drawing that was shown today for the first time, but also all of the testimony that's been painstakingly recited with reference to the record by Mr. Getty, is that the entire premise of the application is still based on the premise that this is one property, and it isn't, and it can't be. So when you reach that conclusion, you can see immediately that they don't get past the starting line. And it's throughout the testimony. I'm just going to, as an example, read from page 192 of Mr. Brewer's testimony on day one of this extravaganza in 2015. Mr. Getty asked him, and specifically with respect to location of number 5, referring to turbine 5, and the requested variance, what is the practical difficulty that generates this variance request? Very specific question, answer. Right. So again, all of the different site constraints must be considered together in aggregate. So one of the sort of internal constraints for wind development, there's a minimum distance requirements between the units themselves, the turbines, after which they no longer function properly. It's actually detrimental to the generator itself. And the answer continues, I'm not trying to cherry pick it, but my point is, specific question, general answer. Right? All of these factors that you've heard so much about, wood rat, the rare plant, mining, go through the whole list. They've been very well set out for you by Mr. Getty. You'll see that they're not assigned to any of the three applicants, any of the three properties on which the non-compliant turbines would be built. Instead, they are attributed to the area generally, as it's shown in that demonstrative exhibit today. Generalized information, aggregated information, it's throughout the transcript. I encourage you to use the shorthand that Mr. Getty provided to you with the references to the transcript. Because when you go back into that transcript and read those pages, you'll see there's lots of conversation about and testimony about wood rat and all these factors we've talked about. But you won't find that there's any testimony about it being on one of the three parcels that I, as far as I can tell, these turbines we built on, with the exception of what I'm going to show you. So what I'm going to do, so that's the first thing I'm trying to, so that is a milestone. Really, the analysis doesn't have to go farther than that. Right? If they can't define and show you the property on which the variance would be granted, they don't get past that. But I do want to go on to my second point, which is I want to go through exactly what they did try to show the first time around with testimony and with plats. And I want to demonstrate the exhibit, the analysis that the Court of Special Appeals opinion requires. And this is going to take a little bit of logistical doing. Before I came today, I marked these exhibits as plaintiff's exhibits 1 through 10. I have 10 total. Mr. Squires has marked the first 3 as exhibit 232, 233, and 234, which I take it will be the actual official designations. And if it's okay with you, I'm just going to pass out the first 3.
Sure, Mr. Getty.
I agree with Mr. Rosas. I was going to make sure you get one.
I think we should give Mr. Getty a second to look at them.
That's fine. I will do it right now.
Mr. Flynn, just so I understand, Mr. Squires is going to be getting the originals? Oh, no.
Well, yeah, I've marked the originals for the board.
Okay.
So as is discussed.
But you have copies for each of the board members.
If you got your numbers in here, if you guys can jump around.
So why don't you hold on to
Present it.
those?
Present it to Mr. Rosas, please.
Oh, okay.
To Mr. Rosas.
Sure. Well, I'm just waiting for Mr. Getty before you guys get it. Just mechanically speaking, since these are color originals, Mr. Squires should probably hold on to these. So, looks like-
Stay with Mr. Rosas right now.
yeah, why don't we just, I'll hold on to those. Those are for the board, right?
Yes.
Okay.
Well, that's one set.
Okay.
Looks
Looks like maps. And somebody's testimony. Who is this? It doesn't say on the transcript, Mr. Flynn, whose testimony is, Mr. Brewer. Thank you. If it's okay with you, I'm actually going to write that on the top, just so it can be easily noted if somebody looks at that. Did you hear that, Mr. Getty? The transcript, I've actually written Mr. Brewer on top because on the transcript excerpt, it actually doesn't say who it is anywhere. Do you have any objection to these exhibits, Mr. Getty?
The wetland delineation came from what is
Mr. Getty has asked me about what is marked as number 234, no, excuse me, 233. And he's asked me what exhibit from the original numbering this came from. And frankly, I couldn't keep track of the original numbering, so I took this out of, I thought it was the triad report, but I could be wrong on that.
I just need.
I understand. Do you dispute that, or? Okay.
I mean, I have no written. After 4 years, I have no way of disputing.
Well, I mean, we could, theoretically, we could hold it, you guys could check that at lunch, but, okay.
Mr. Flynn's on it.
That's fine. I would recommend the board just accept these then. Exhibits.
I'll accept it.
Then I'm going to give Mr. Squires the originals back for the record, and then these goes to the board. Pass this down, please.
Yes, sir.
Extras or just one?
No, they each get one of those. Yeah,
Wow,
sorry.
thank you. I'm overwhelmed. Thank you.
And everybody has one, right? It's 2 maps and a transcript, sorry. Yeah. Thank you, Mr. Flynn.
This is Mr. Brewer's testimony?
Yes, yes, Mr. Brewer.
This is Mr. Brewer one.
That's correct.
All right, so I apologize, that was logistically difficult, but I want to pair up for you the testimony that goes with, and I'm referring to what's marked as 232, or Plaintiff's Exhibit 1. And what I've done is I've stapled together the pages of Mr. Brewer's testimony from day 1 that address Turbine 5 and structure, what's called Structure 1, the Kiter or Keter residence. And I've paired those pages of the transcript with this plat, which is marked at the bottom as Exhibit A1. Frankly, the numbering of all this stuff gets terribly confusing, so I apologize. But the transcript and the map that goes with it go together. And what I've done here is I've attempted to isolate the pages that are the only ones that I could find and are consistent with Mr. Getty's presentation in terms of the citations, at least to the extent I could take that information in this morning, where this was the effort of the witness in total to attribute these factors, these characteristics supposedly justifying variance to any particular property, as opposed to some conglomeration of lots of properties. And so what the board will note is that in this testimony, the first factor that is discussed by Mr. Brewer when he's asked to specifically talk about why the number 5 variance, the number 5 turbine variance is requested, he chooses to talk about the operation of the turbines and that they can't be too close together. That's the first one he chooses to talk about. But I want to bring the board's attention back to the definition of zoning variance in the code, and that is 360-59. And there, it is very specific. It talks about physical or natural characteristics of the lot. And this is also consistent with the Court of Special Appeals opinion in this case. On page 13, where it defines the very first task of this board on remand as the board must determine whether the unusual factors identified by the applicant are, in fact, features of that particular property. And so what you can see right at the outset is what this board is to be looking for are features of the property. And yet, in answer to this question, the very first thing that we get from Mr. Brewer, an answer in the testimony, has nothing to do with a feature, a physical or natural feature of the property. Instead, it talks about the internal constraints of wind technology. And you also heard multiple references to this in the presentation this morning. I would submit to this board that that is not an appropriate factor for consideration under either the zoning definition of zoning variance in the Allegheny County Code, nor is it appropriate under the Court of Special Appeals opinion as a factor that can be weighed in determining whether the variance is granted. Now, the second factor that's identified in this testimony is wetlands. And you can see, if you fold out the map that I've attached here, under Plaintiff's Exhibit 1, now if you look in the middle top of this plat, you'll see the number 5 turbine. And just to the north, northwest, slight northwest, you have a square area, and then further to the northwest you have a sort of a longer area which appear to depict wetlands. And you'll also see, I handed you it's marked as Plaintiff's Exhibit 2. This is the wetlands study, at least part of it. And you'll see on page 5 of 6 of number 2, in set K, this appears to correspond in space to the wind turbine 5 and the wetlands that is supposedly limiting its location on this property. So there we have success, right, for the applicant, right? We have a wetland that is actually on this property, and we have evidence of it being there, and that becomes our first factor with regard to the variance that's requested as number 5. So let's continue to go through the supposed factors here in the testimony so we can collect them, because the 3-part test of the Court of Special Appeals requires that we put together the factors that actually exist on the property, we put them together, and we decide whether they are connected to or have a nexus with the variance that's requested. So if we continue through his testimony, the next thing he talks about is environmental site design. Well, we heard about environmental site design this morning as well. It is, according to Mr. Getty, a Maryland requirement, but it by itself is not a physical or natural feature of the property where this non-compliant turbine would be built. And I would submit that it's not an appropriate consideration for a factor to be weighed in whether this property is unique or not, because frankly, it applies to every property. According to Mr. Getty, it applies across the state to every one of these properties. And so that, to my analysis, is not relevant to the uniqueness test that the Court of Special Appeals would have this board apply. Fourth, Mr. Brewer identifies the beam path. And I've provided, as Plaintiff's Exhibit 3, number 234. This is a two-page exhibit, and Mr. Getty referenced this as well. This is the two schematics showing the various point-to-point beam paths and multi-point beam paths in the vicinity of this project. But you'll note on Plaintiff's Exhibit 3, or number 234, it doesn't show turbine 5. It's not there. Nor have I been able to find any reference to the Lohr property, parcel 29, I believe it is, where number 5 would be built. Now, if you check his testimony, Mr. Brewer's testimony that is stapled here as Plaintiff's Exhibit 1, he doesn't actually testify that any of the beams cross the Lohr property. What he says is that number 5, turbine number 5, was designed consistent with the beam path study. So whether that means in someone's mind that there's a beam or beams that cross the Lohr property that somehow require the tower or the turbine to be where they've drawn it, that would require quite a leap of reasoning. But the reality is that it's not even shown here. So by that review, the only factor as to turbine number 5 that gets past the first question in the Court of Special Appeals test, which is, again, let's identify physical or natural characteristics of the property on which the non-compliant turbine will be built. The only factor identified in Mr. Brewer's testimony about turbine 5 that gets through the first question is the wetlands. Right? Everything else he talks about doesn't meet the criteria. Right? So what then? What is the second step in the Court of Special Appeals analysis? That second step is, do those wetlands have a connection or nexus with the separation distance variance sought here? Well, what do we have? What do we know about this? What we know is that the Lohr parcel is 137 acres. We know that we have a partial depiction of that parcel in a number of places in the record. If there is a full depiction of that parcel somewhere, I haven't seen it, I haven't found it. And we know that we have depicted on several of these exhibits small, I'm going to call them postage-sized wetlands, postage stamp-sized wetlands. Right? Where is the evidence that these tiny wetlands on a 137-acre parcel have any connection whatsoever with the need to place turbine number 5 too close to this residence? Now, let's say, just for sake of analysis, that we somehow answer that question favorably to the evidence, that these tiny wetlands are connected to this variance request, as the Court of Special Appeals requires them to be. The last question the Court of Special Appeals requires us to ask is, well, is that unique? Where is the evidence that wetlands, similar wetlands, don't exist all around this parcel, on nearby parcels? Now, Mr. Getty suggested that that burden somehow shifted to the opponents of this application back in 2015. I think the Court of Special Appeals is very clear. The burden for all of these questions lies squarely with the applicant. It's the applicant that has to come forward with evidence that these tests are passed. So where is that evidence? It's not there. There's not a shred of evidence, and it's not unique, even if you do get to the third question. Right? You don't really get there. But this is the analysis that's required as to each one of these non-conforming turbines. Now, we're going to quickly get into lunchtime, but what I'm going to attempt to do here is mark and provide to you similar exhibits where I am connecting transcript pages from Mr. Brewer's testimony to the matching plats showing the variance request. Because frankly, that was the only way I could make any sense of this in my own head. And I wanted you to have that in front of you rather than a table full of documents. So if I could, I think we're on number 235. I will first show this to Mr. Getty. Mr. Getty has no objection.
No objection. None. And you gave Mr. Squires the originals?
Well, he gave this back to you. Do you want it?
Okay, all right, that's fine then. All right. Thank you. Just want to make sure we don't lose something somewhere. Is this Mr. Brewer's testimony again, Mr. Flynn?
Yes, sir. This occurs in the transcript immediately after the portion we were just looking at. Okay, so I'm going to try to move through this as quickly as I can. What I've attempted to do is try to perform the analysis that the Court of Special Appeals has required as to each of these variance requests. And I've tried to do it based on the transcript and the materials that are in. And so I apologize if it gets somewhat tedious, but this testimony paired with this plat has to do with structure number 2, the lower residence. And this tower, which is number 11.
11, I believe.
Turbine 11. As far as I can tell, this is to be built on the Sportsman Club's 713 acres. Now, that appears on many of the plats we have in the park. I haven't found a full plat of that property, but it appears that that's the property where the non-compliant Turbine 11 would be built. Here again, the testimony of Mr. Brewer identifies beam paths as a factor to be considered as to this variance. But he does not testify that those beams actually cross the 713-acre parcel. Now, can that be surmised by some of the evidence in the record? I'm not sure. As you saw, Mr. Getty attempted to transpose various pieces of information onto his demonstrative exhibit. Perhaps the board members feel that they're capable of doing that, but I personally can't figure out, based on what's in the record, whether or not the beam paths cross the Sportman Club's 713 acres. If there's something here that shows that, that would be important, but I have not found it. Also note on Exhibit 3, Plaintiff's Exhibit 3, which you had from before, turbine 11 is not here. This Exhibit 3 is the depiction of the beam paths. You won't find turbine number 11 on that. Mr. Brewer testified about wetlands. And here again, you can cross-reference with Plaintiff's Exhibit number 2, which is the soils report and the wetlands study. And you can see, yes, in fact, there are wetlands on the Sportman's Club property. So that's one factor we have to take into consideration. Mr. Brewer identified the wood rat habitat. But as far as I can tell, there is no wood rat habitat on the 713 acres. It's not there. You can cross-reference, there's these plats that are all the way at the bottom of my desk here, and I couldn't make copies of them, but you have them obviously. It's called C4 is the plat reference. And you can see on C4 the green depictions of the wood rat. You probably have seen it when you're looking at these documents. The wood rat habitat is depicted in green on C4. As far as I can tell, none of it is on the 713 acres where non-compliant turbine number 11 would be built. Now here again, Mr. Brewer, you'll see in this testimony that I gave you as number 4, Plaintiff's Exhibit 4, he talks about, as his fourth factor, that shifting one tower would require shifting many others in the line of turbines. Now here again, this theme continues to come up in with reference to almost every variance, that a major factor in how they're placing these turbines has nothing to do with the physical or natural characteristics of the land on which they would be built. Rather, it is a function of the technology of the turbines, which is not a relevant consideration or a proper consideration under the Court of Special Appeals opinion or under this county's code defining a variance. So here again, we have, we're left with wetlands as a permissible factor to weigh the next question from the Court of Special Appeals, which is, do the wetlands matter? Right? Are they connected with the variance that's requested as to this turbine? Well, you can review Plaintiff's Exhibit 2, and you can review all of these maps, and I hope you do, because what you will see that there are not significant wetlands on that acreage. You're sure there's some wetlands on there, but it's 713 acres. Where is the evidence that those wetlands are driving, causing the need for the variance? It's not there. And frankly, it's implausible. I'm going to show Mr. Getty what I've marked as Plaintiff's Exhibit 5.
No, what I take it is, this is his comment, the same as if he were at trial. He would say, you shouldn't believe this expert because this is what he testified to, but it doesn't make sense for this reason. Right? It's not positive evidence, it's negative commentary on positive evidence. So, because you're entitled to take Mr. Brewer's testimony and toss it out the window if you don't believe it. You're not required to believe it. There wasn't refuted. There's no opposing testimony, as I understand it. I didn't see any. I'm sorry. Just to be, for full clarity, the question was, this is not evidence, and my explanation to the board is, Mr. Flynn is entitled to criticize the expert opinion of Mr. Brewer. What he's saying is not evidence. He's simply pointing to the board as to why the board should not accept Mr. Brewer's testimony. The board is entitled to believe all, some, or none of Mr. Brewer's testimony. And that's my understanding of what he's going through now.
Well, and just to clarify that point, I'm not attacking the credibility of Mr. Brewer at all. In fact, what I want the board to do is look closely at his testimony. Look what he actually says. Don't let the aggregate analysis hold here, because there's lots of sort of shiny turbines and lots of hard work, but by some very impressive people to design a really impressive concept on this mountain. But what they've proven with all their work and all their money is that this can't be built without changing or breaking the law. That's all they've shown. So I'm not attempting to criticize Mr. Brewer at all. I would like the board to look very carefully at what he actually says and see that he's not ascribing factors that can be weighed in the Court of Special Appeals' analysis to specific properties, as they have to be attributed to the specific property where the non-compliant turbine is going to be built. And that was never done. And it was never done in this case because the applicant was leaning on the zoning merger concept. They tried to treat it as a single huge property. They've been trying to do that from the beginning. They appear to have, maybe they've decided just not to use the term anymore.
I object to the suggestion that zoning merger is done well. I mean, simply because it wasn't, it's part of the record. It is there, it's in every court case, it is in every thing we've done.
I think that's a good issue for you to address in your rebuttal, Mr. Getty.
Is there an objection to number 5, sir? All right, this has been marked as 236.
Well, thank you. And this is Mr. Brewer again?
Correct.
Is it all going to be Mr. Brewer?
It's all Mr.
Okay.
Brewer.
Okay, sure. Okay, we have to do a quick recess for technical. You had to change the tape out, so reset at this moment. We'll come back in about 5 minutes.
Thank you.
Thank you.
Thank you. Okay, so the board has now Exhibit 236, which is also marked as Plaintiff's Exhibit 5. And here again, I've paired the testimony of Mr. Brewer up with the corresponding plat showing the requested variances. And these have to do with turbines 11 and 12. Now here, we start getting into more complication because the way this was drawn up, number 11 is on the Sportsman Club property, and then 12 is on the BOZA Trust property, as far as I can tell. And so what we have in his testimony about wetlands, wood rats, and the beam paths, okay? Now, as to wetlands, you can see them when you reference the plat. You can see them on the Sportsman Club property, but not on the BOZA Trust property, at least not that I've been able to find. The wood rat habitat is not on Sportsman Club property. It is there on the BOZA Trust property. You can see that there. And the beam path, again, as we've talked about, number 11 turbine is not even shown on the beam path depictions, which are on one of the earlier exhibits. So when you take the analysis that the Court of Special Appeals has required of you, would have you go through, find and verify the natural and physical characteristics of these of the specific property on which the non-compliant turbine would be built. And once you identify the proven factors that exist, then with regard to those factors, you must ask yourself, what is the connection? Right? And here, most importantly, you have to bear in mind the property that you're being asked to make the variance for. With regard to what I'm calling the Baugh Trust property, that's a 1,700-acre property. Now, the wetlands that are depicted and the wood rat habitat, is there any logical way to look at the evidence that's been presented and conclude that these tiny habitat areas, tiny wetlands areas on properties of that size are actually the dictating factors or the causes of these variances being needed? Or is it much more plausible that what's going on here is that the turbine locations are being dictated by the turbine technology, which is not a physical or natural characteristic of the property? Now, I'm going to move through the rest of these more quickly and spare you the marking of some of this stuff and go through the other items here so we can break for lunch. So with regard, in Mr. Brewer's testimony on pages 201 and 202, this is the only 2 pages in which I could find there was any effort in this process to,
It's in 5. It's exhibit.
no, excuse me, I'm moving past, I have a number of other.
I'm sorry. Okay.
We'd be here all day if I kept trying to mark all these. I
Okay,
apologize.
all right, sorry.
I mean, they're all in the record, you have them. I think you're, I don't want to belabor the point too much, I think you're getting the idea. What I'm trying to show you is this is the analysis that the Court of Special Appeals will require. And what I've attempted to do is find any point in the transcripts at which Mr. Brewer or anybody else even attempted to identify information that would allow this board to grant the variance that's being requested. And so when you go through the other pages, and frankly, they're the same pages that Mr. Getty identified in his presentation, same page references from the transcript. When you actually read them, you have to look and determine, is Mr. Brewer actually testifying that this factor, whether it be a wood rat or whatever, exists on the property where this non-compliant turbine is going to be built? First. Second, is that factor, combined with any of the other ones that I can see from the evidence actually exist, is that factor, or all the factors, are they connected with the variance that's being requested, or are they just window dressing? You know, is it even plausible that these minor factors would dictate on parcels of this size such a narrow envelope? And that's a phrase that Mr. Brewer likes to use in his testimony, that there's a narrow envelope on which he submits that this could have been built. Now, maybe that's true, and he knows a lot more about wind turbine technology than I ever will. But that's not a factor on which a variance can be granted. That's the analysis that the board has to go through. Sorry, I'm going to try to wrap up here. The board's indulgence, just a moment.
Go ahead.
I've been talking about this second question the Court of Special Appeals requires of this board. The question, the nexus question, the connection. Right? And I want to go back to the Court of Special Appeals opinion just to read 3 lines from pages 10 and 11 of this opinion, just so that you understand exactly why the question needs to be asked. The first thing, I'll read straight from page 10. The owner must prove a connection between the property's inherent characteristics and the manner in which the zoning law hurts the landowner. It's not good enough just for that factor to exist on the property. It has to actually be connected. On page 11, the court continues, rather than semantic tricks, the proper question is whether the property is unique in the way that this particular aspect of the zoning code applies to it. And then thirdly, the court on page 11 uses an example. it would make no sense to consider the narrowness of a pie-shaped lot as a unique attribute in considering whether to waive, for example, a height or density restriction. And that's the point I'm trying to get across to you. It would make no sense to consider a tiny habitat here, or a tiny wetland over there, or a narrow beam here, even though we're not really sure where it is, right? When you're considering whether this, where the applicant has drawn turbine X, whether it's 11 or 12 or any of the 12 non-compliant turbines of the 17, when you consider whether this is the only place that that turbine could go, right? Is there really a connection between that decision and these natural and physical characteristics that they're citing? That's for the board to weigh, and I'm just here to argue. Obviously, this is my view of the evidence, and it's the board's job to view the evidence and make conclusions of its own. The court will, the board will find, as it goes through the citations that Mr. Getty has provided, and they go through page 212, I believe, of Mr. Brewer's testimony, that time and again he is admitting that moving one turbine would require impacts all along the array. And multiple times you'll see that in the testimony. And when I submit, when the board actually looks at these maps and this evidence and considers what makes sense, the board will find that that's actually what's dictating these locations. And then perhaps more challenging for the applicant is that they very intentionally have created this omelet, this sort of combination of factors that includes the technology of these wind turbines, right? They have said, well, here's a dozen bullet points, and these are all factors that exist on this grand sort of non-property that we keep drawing on demonstrative exhibits, but it's not actually a lot. But here are all these factors that exist here. And they're mixing into that omelet this concept of turbine technology. So that's their decision. That's how they decided to present this case. And it's based on this concept of zoning merger and the concept of this being on property. And Mr. Gutty has clarified that it sounds like they're maintaining that argument, that doctrine should be applied. But I've found no information here in this record based on which this board could unmake that omelet. How is the board to separate out the turbine technology from that omelet of factors that aren't really ascribed to any particular location? There appears to be no way to do it. And perhaps there are experts, I bet you there are experts that are working for the applicant that would have lots to say about this. But the record's closed. And I've been unable to find anything that would allow the board to make that kind of decision. For example, mining. Right? We heard about mining references this morning. I would challenge the board to look for any evidence of mining activity in the record around the non-compliant turbines. I haven't found it. I haven't seen any evidence of the mining activity even on the parcels where those non-compliant turbines we've built. It appears that the mining activity is way off to the top of this, sorry, I didn't bring my compass with me, but way off to the side of the project, where at least the mining drawing that I saw. So it's essential that the board drill down on these factors that are just being ascribed generally to the project and actually see how it all fits as to specific properties. And then I will just wrap up here by referencing one more time back to the Court of Special Appeals opinion, because I've not really focused on the third question of the uniqueness analysis, because frankly we don't even get there, because they can't show the factors exist on the actual property and they can't show the nexus. But let me just spend a moment on the third question, if somehow we get there. And the third question is it unique, right? Is the factor on this property that is connected with this variance request, is it unique? And this is important. The Court of Special Appeals gives us several reasons why this is an incredibly important question that has to be answered. First, and I'm reading from page 9 of the Court of Special Appeals, if the allegedly restricted effect of the zoning law is not unusual and a characteristic is shared by many properties, the problem ought to be addressed by legislation, not variances. Page 10. A property that is affected uniquely may be entitled to relief through a variance, while a property owner experiencing a more common problem must seek a legislative remedy. Just further down on page 10. If the effects of the zoning law operate similarly to the way in which they operate on a separate applicant property, the uniqueness requirement is likely not satisfied. So, by approaching this problem in the way that the applicant has approached it, and aggregating all this information about the factors, they've said, here are these dozen factors, they apply all over this acreage, they're endemic. It's a self-defeating proposition. They've established for themselves that these are factors that exist all over the vicinity, and there's nothing unique about them. And if they're holding up this project, then the change that needs to happen is legislative. It's not for this board. So I do have additional comments, but I want to respect the board's intention to take lunch,
Well,
if I may, after lunch.
We certainly can finish up after lunch.
Okay,
Yes.
that'll be fine.
Okay, we'll recess for lunch. How much time does everybody think we'll need? Have any particular time? It's 12:15 right now. Is 1 o'clock okay? Mr. Flynn?
1 o'clock, okay, Mr. Flynn?
Yes, sir.
Okay.
Okay. Recess till 1 p.m.
Yeah, what was the headlines?
Someone's always irate about something.
Oh, yeah. Are we good? Okay.
Okay, we're back in session. Mr. Flynn, have you completed?
I have maybe 10 more minutes.
Go ahead, please.
Thank you very much. What I've tried to do this morning, excuse me, Paul Flynn for the record, I've tried to show a few things this morning. I've tried to show that the applicant has not actually shown us the properties in an appropriate way. I've tried to show that they've failed to do that because they're treating this project as one big property, which is a fiction. But it is also a crutch. And when you remove that crutch, I'm suggesting to the board, and this is my argument, that it all falls apart without the crutch of the fiction that this is one huge property. Third, I've tried to walk the board through the uniqueness analysis that is required by the Court of Special Appeals opinion per property, per factor, physical and natural factor. And I've tried to walk through both the first question, which is, does the factor exist on the property? The second question, which is there a nexus between that factor and the variance requested? And the third, is it actually unique? And then I'd like to try to, at this point, address what happens after the uniqueness analysis. And Mr. Getty alluded to this. There's a practical difficulty test that is applied. The Court of Special Appeals does not spend a great deal of time on it in its opinion, but on page 17 of its opinion, it says that the board should have reviewed the requests under the more lenient practical difficulty standard as outlined in the Rotwein case, which is a Maryland precedent. And I read that because there's an important distinction in the Rotwein case, which I'm not going to belabor because the board has very capable counsel that can assist with the legal analysis. But in the Rotwein case, there's an important distinction between a practical difficulty on the one hand versus a self-created problem on the other hand. And here what we have is a situation that's, I think the strongest inference and conclusion that can be drawn from the evidence is that what we have is a situation where the turbine technology is dictating how this project's being laid out. And the question that the board should ask itself with regard to practical difficulty is there actually evidence in this record that there is practical difficulty in building a turbine on the lower property, or on the Baugh Trust property, or on the Sportman Club property? I would submit that there isn't. What we have at best is evidence that a 17 turbine string, a string of 17 turbines cannot be built across many properties without lots of variances. I think that's what the record has shown. Now that's not a practical difficulty with regard to any specific property. That's a self-created problem. And the board should review the Rotwing case because that is an important distinction. And though the practical difficulty is the more lenient standard of the two, it is still a standard, and it's not met in this case. I told you at the beginning of my comments that the fifth thing that I wanted to do today was try to debunk this myth about a variance from the applicants to the applicants. This is a very unusual situation, and the opponents to this project have been painted as trying to protect the applicants from themselves, in a sense. And the suggestion has been throughout the record and today that the opponents have no business doing so because what business is it of ours whether the applicants wish to subject themselves to these kinds of conditions. What's lost in that analysis is that Anchor in particularly is a property rights group. We're not here to protect applicants from themselves. If they want to subject themselves to certain conditions, they can have at it. What we're here to protect is our property and our rights. And our right is to demand that the law be applied as it's written, fairly and evenly, with no special deals for big money interests. Because what happens out there affects the whole community. What's important to understand is that landowners cannot conspire among themselves to work around zoning rules, right? If my neighbor and I decide that we think it'd be really fun to build our houses such that we could pass notes across from our kitchen windows to each other, right up against the property line, and we're both on board with it, we think this is a great idea. That doesn't mean that we automatically get a variance for the setback requirement. That decision would affect the whole community, and it's the whole community's right to require and demand that its government apply the rules evenly to all of their neighbors, because everybody has to live by the same standards. Now I'm going to flag this point in my presentation just because this came up earlier. There's an issue that is kind of in the record, kind of not in the record, and I know Mr. Getty will have an objection to this, although he raised it earlier, I think, but there's this issue about the Lashbaugh application, which is part of this set of variances. The Lashbaugh property is now owned by the Wilsons.
Again, I do object. I know the issue with Mr. Rosas. We are dealing with a record that existed, there are burdens on that property without knowing whether the property is sold. There are agreements in place that the landlord and the owners, it is not relevant to any issue.
You did raise it, though, in your presentation, I point out. Do you believe that you believe that's not a waiver of the argument? Mr. Flynn, your response?
I think the board needs to hear this because I think it presents a jurisdictional problem. Now, I defer to the board's analysis on this, but if if a property owner applies for variance, and then while the application is pending, sells the property and moves out, and the buyer doesn't support the application that's pending, is that still a valid application?
Isn't the, I'm not sure I understand your jurisdictional argument, isn't the subsequent buyer bound by the easement to sign off on the
Well,
application?
that's just it. I'm not aware of an easement on this property. Now, again, this is what I'll say from the perspective
Sure.
of in a on-the-record remand like we're in. What I will say is that I do not believe the record contains an easement as to this property.
Okay. Mr. Getty, can you answer that question? Because I don't know the answer off the top of my head.
The answer is there is a memorandum of lease and easement agreement on the property that applies to the property. The ownership of any of the property, once the application for land use is made, is not relevant to any issue for this board to determine.
But you're proffering that a memorandum exists, but it's not in the record. Is that fair to say?
The applications, the only application that is before this board for a variance or a special exception is signed by the owner of all of the properties involved. Each of those owners then have a lease memorandum easement agreement in place as a backup, and that's what generates the consents that are there, which are a part of the record.
I'm assuming they're a term of the
They
easement.
are all
Yeah.
part, they are all part of it. Each of those people has signed off making the application. No landowner has petitioned this board or come to this board short of the argument that's being made this morning to suggest that his property is not subject to the initial application by the prior landowner or the agreement that's in place. And I don't think it's relevant or something that the board can consider in terms of any decision that's been presented to it on remand.
Okay, thank you. Oh, I'm sorry.
And just to close the loop on that, I would proffer that it's also relevant under the, using the 2015 codification, section 360-92A and B, to my reading, has a present tense requirement of written authorization for the property owners who are involved. So I know Mr. Getty's position is that the past tense authorization from the past owner is sufficient under that statute. The fact is, that person doesn't own the property anymore. This is a little complicated, but I think the board needs to at least consider that.
And I would point out that Mr. Flynn has not advanced any legal authority that would allow this board to take the action that I think he's urging on the board. You know, so that we can be clear, if, and this has not happened, but if the landowner, the new landowner, came and disavowed the agreements that are in place and that are burdens on his property, that would be something that the landowner would be exposing himself to.
I guess the difficulty it's contractual, he would be exposing himself to lawsuit.
Absolutely.
Yeah.
Including up to it, including injunction.
I guess the issue that I'm seeing is I shouldn't say this. I am 90% sure that there exists an easement that contends that the property owner must consent to the application, and that whoever bought the property, the Wilsons, did you say? I'm sorry. The Wilsons purchased that with that easement on the record. The problem I'm having though is that easement being on the land record. The problem I'm having is that easement and agreement is not in this record.
Because it's not relevant to any issue in this case based on the ruling. It may be a post-remand issue that, if Mr. Wilson and Mr. Flynn chooses on Mr. Wilson's behalf to address it, but it's not an issue for this board in the context of the Court of Special Appeals.
Do you have any comments based on my question or my comments, Mr. Flynn?
I think I'll leave it there. I would suggest that it's thorny. There's not clear guidance as to what should happen. So I'll move on.
Well, I certainly want to talk to the board about your presentation, your issue, and your question.
Let me also point
your
out, there's
objection.
nothing in the record suggesting Mr. Wilson owns the property. I understand the property by Mr. Flynn.
Sure.
I understand what
True.
everybody might believe. But
Yeah.
we're dealing with a record, and
That's true. Okay, does everyone understand what the issue is here? So,
I don't see how you can separate the two, though. I'm talking reality versus what's on paper.
yeah, I mean, that's what
Okay,
we're
that's
talking
what we're
about.
talking about, reality versus what's on paper.
Yeah, but sometimes what's on paper is what's
Yeah,
important.
and that's garbage.
I can't imagine.
My opinion.
Yeah,
I can't imagine how it was conveyed without that.
I'm sure it was, but it's not, because it was never an issue in 2015, and never became an issue. So, yeah, Mr. Getty's argument is that the land transfer that occurred isn't even part of the record either, so we can't discuss that at all. I agree. That might be, I think that might be the cleanest solution is to take the position that the land transfer itself isn't part of the record, so we're not gonna look into any of that. Unless and until the Wilsons come in, and if they file a petition to withdraw their application, that's between them and, yeah, they get sued and they go on from there, yeah, and then we make a decision on that. Does that seem reasonable? Okay. I think the board's conclusion is that we're going to exclude evidence of the land transfer and any change in the applicant's position post-December 2015.
And just procedurally, I'll note an exception.
Certainly, your exception's
To that,
noted to that, counsel, yeah.
I think I can wrap up now with the board's indulgence. Just in conclusion, the bill that led to the controlling code section here as to wind energy in Allegheny County, Bill number 2-09, amended June 4th, 2009, it does indicate that its purpose is in part to provide additional protection for the public and adjoining landowners. And what I think has become just painfully clear through the thousands of pages of this record is that Mr. Getty and his team of very impressive experts have set out to design a 17 turbine, or I think at one point a 19 turbine wind energy project across numerous parcels. And they've turned over every leaf trying to figure out how to do it. And they've studied every possibility. And what they've shown and demonstrated beyond doubt is that a 17 turbine wind energy project across all of these properties can't be built without breaking the law or changing the law. Now, administrative agencies like this board, it's not your responsibility to change the law or to rewrite the law. And what we ask is that these applications, or this application and these variances, be denied. And if they need it, if the applicants or the proponents need to change the law, then they need to go talk to somebody else. Thank you very much for your time.
Thank you, counsel.
Thank you, Mr. Flynn.
Does any member of the board have any questions for Mr. Flynn?
No, no, this is not.
Okay, I actually just have a couple, Mr. Flynn. And these are probably out of order, so I apologize. You talked about mechanical difficulty not being an issue for the uniqueness of the property. And I understand your point there. I guess my question is, mechanical difficulty an issue that can be considered in the practical difficulty phase, or the practical difficulty prong of the question?
It could be. It could be relevant under a practical difficulty analysis if that practical difficulty was shown with respect to a property. So if there was a showing that a wind energy system could not be built on the lower parcel, or the other two parcels that we've been talking about, the Sportsman Club and the Ball Trust property, if there was a showing of practical difficulty that would prevent, based on the mechanics of the turbines or design or specifications or whatever, that would prevent the building of such a system on one of those properties, sure, that would be absolutely relevant to a practical difficulty analysis of those properties. But that's not been shown. All that's been shown is a practical difficulty building a 17 turbine system across numerous properties. And that's not relevant to the analysis of any practical difficulty as to any specific properties. If the Court of Special Appeals opinion means anything, it means we have to take this by specific properties.
So, and I don't want to put words in your mouth, if I understand you correctly, your position would be there would have had to been testimony either from the expert or somebody else that wind turbine 12
if it got 100 meters closer to wind turbine 11, would reduce its efficiency by 20% or something like that.
Well, that would certainly have put more detail on it, but even that, I'm not sure would have sufficed, because what's required as a factor to be considered in the variance formula, and the practical difficulty question is just one component of that analysis. The factors that can be considered are physical and natural characteristics of the property. And the technology, today's technology versus 10 years ago technology versus 10 years from now technology, it's changing. It has nothing to do with physical or natural characteristics of any of these properties. So it's just not relevant.
I'm sorry, there was something. I know I'm opening a can of, well, let me ask you a question. You had alluded to, an issue that's come up in your presentation, and I'm sure that Mr. Getty's going to want to address, is the zoning merger issue. You alluded to, the Court of Special Appeals, in my reading of the opinion, is very skeptical of the zoning merger opinion, or zoning merger theory, but to be fair, that's merely dicta in their opinion. Would you disagree with that it was dicta? I don't think it was, didn't read it as a holding.
I agree with you. That's not a holding. Basically, what we have now are 4 Maryland judges, starting with Judge Finan here, and 3 members of the panel in Annapolis that issued this decision, all expressing significant reservation and doubt as to the validity of that theory. And of course, this board rejected it in 2015 as well. So it's unanimous so far as to decision makers. And the Court of Special Appeals, as I read it, has anticipated that the High Court would refuse to extend the doctrine as the applicant would have them extended.
You spoke about, I'm sorry. I think you answered my question. Thank you. Do you want to have any other opponents speak before Mr. Getty gives his rebuttal?
Yeah, I'd like to address a play of words you made. I'd like to make sure I understand what you're talking about. At some point, you remarked that we were given a package, and in your words, like an omelette, tried to decipher the individual eggs out of there, which is basically impossible. So is it in your opinion that the Court of Appeals gave us an order by remanding it back to this board that in no way can be fulfilled? They tied our hands behind our back by not being able to decipher the individual eggs with the testimony that is at hand.
The Court of Special Appeals, in reviewing the record, they review the record for their purposes. And so in remanding the case, is it a job that, I'm sorry, let me start that over again. Given the record, my position is that the board could not find in the record the evidence necessary to grant these variances based on the Court of Special Appeals' tests as they have laid them out. Now, I want to distinguish that from and I'm not sure if this is what you're getting at or not, they've not set up an impossible test. They've set up the test, and it just so happens that the facts of this case can't meet it. So did they perform an analysis in Annapolis that would get to that level of granularity? No. That's not what happens there, which is why the quotation that Mr. Getty kept pointing out about the suggestion that they've already somehow concluded, it's just, I disagree with that respectfully.
Okay, I understand that the appellate court decided that they did have enough information to, if they so wanted, come up with a solution, or at least an answer to the problem. But they decided to remand it to us because it is our jurisdiction. Do you disagree with that?
I don't recall the portion of the opinion from which I concluded that they, I don't believe the Court of Special Appeals thought that it had the authority to grant the variances. Is that what you're suggesting?
What I was suggesting is that they say they do not have the authority, but the capability is so desired, but because they didn't have the authority, they brought it back to us. Am I correct in those assumptions?
It's difficult for me to get inside the head of the judges, but as I understand it, it's not their role to have done that. And whether they had formed some sort of opinion about what the merits of the case was or not, that's not their role. And so I can't get further inside their heads than that.
Thank you.
I actually just have a follow-up question, I'm sorry. They did use the term legally sufficient evidence, which in my experience as a litigator means they felt there was enough there to get over the burden of persuasion, right? I mean, there was enough there to get to the end, as I understand that term. Does that influence your argument or our decision in any way, you think?
No, this board needs to make its own decision.
Completely de novo. Well,
Without regard to or deference to that sentence, which is at best dicta, and it would be error, in my opinion, to defer in any way to that. Now, I mean, yes.
thank you. Anyone else? Questions? Okay.
What procedure is it now?
It would be whoever I think wants to speak. And again, that's the last hearing any against speakers. 3 minute and obviously addressing all of the evidence that's been presented.
Okay, at this time, I'd like to open the mic up to other parties that are joining in the opposition to the applicant. Is anybody that's registered to speak at this moment? Could you please come to the microphone, please? Do we have a microphone available?
I think they're using it.
No, that please. No, it's okay. Please state your name and address.
Catherine Russo, and my address is 12363 Summit Circle, Frostburg, Maryland.
Thank you.
Okay, I know you want us to speak on what was just presented today in the evidence. We were not here for the 2015 hearing. Our understanding, I'm speaking on behalf of me and my husband, Mike Russo is also in the room. The Maryland Court of Special Appeals remanded these cases to be reviewed by the Board of Zoning Appeals back in 2016, which was 3 years ago, and it has been 4 years since the original Board of Zoning Appeals decision. Conditions have changed since then. People have moved in and out of the area, and they may or may not be within these setbacks and variances that are in place. The properties, as we have seen, have been sold and have caused, which is causing other issues as well. There has been a lot of talk about the impact of the environment to include the wetlands, the wood rats, and the endangered plant species, but I think the focus should be on the inhabitants, the impact of the inhabitants already, of the people that are already in the communities. We recently moved into Allegheny County from Montgomery County and live within 1/2 mile of several of the proposed wind turbines. We live in the Harwood community and are currently working with developers of our neighborhood and Dan's Mountain Solar Company to have a solar farm placed on the lot adjacent to and directly behind our house. The community has met with the representative of the solar company who's advised us about the project and the impact it would have on our community and the environment. We bring this to your attention so that you know that we're not opposed to wind turbines and renewable energy, but it is just we're opposed to renewable energies that have an extremely overbearing impact on our lives. And in comparing the two, we have discovered the following. Wind turbines are several hundred feet tall, about 490 feet, and the solar panels sit on bases that are 8 feet tall. Wind turbines generate noise that is equivalent to the sound of jet engines, and the solar panels do not emit noise. The wind turbines require blasting 40 feet or more into the ground to set their bases, which would negatively affect the water aquifers that supply water to the surrounding residents, and the solar panels sit on bases that are level with the ground and dug only 8 feet deep. The wind turbines emit infrasound, which has negative health effects, and the solar panels do not emit infrasound. Solar panels are more efficient in generating electricity than wind turbines. The wind turbines produce a constant flicker that overshadows homes and yards, and the property values of the homes surrounding the wind turbines will be significantly reduced, resulting in an inability to sell the homes and move away from the mentioned negative factors. Allegheny County has in place certain laws and restrictions for building wind and solar farms to protect the environment and residents that live near them.
It is difficult, and I appreciate that it is with members of the public to fully appreciate what the nature of the hearing is, but it is confined to the record.
And I think actually she's getting to the discussion of the statute. So I would just remind everyone, we're talking about as of December 2015.
Yes, I'm wrapping it up. It'll be
Okay.
only a few more seconds. Okay, Dan's Mountain Wind has been trying to circumvent those laws for years to push their project through. We understand both projects would provide tax revenues for the county, but that money should not override the county government's responsibility to protect its citizens. We are appalled that this has gone on for so many years. The citizens of this county should not have had to hire a private attorney to defend the laws that were put in place by the county government to protect its inhabitants. They should have been defended by a representative of this government who was elected by those same citizens to do just that. Based on these facts, we feel that the Board of Zoning Appeals should uphold the original decision that was made in 2015.
Thank you,
for your
ma'am.
time.
Just sort of the same reminder to you that we should be focusing on arguing about what the evidence is what is in evidence as of December 2015.
First initial C, Philip Bush. If Carolyn is in the room, I do rise in support of the points that were just made. And I did read the decision of the Circuit Court. I'm not a lawyer, but it seemed quite clear to me. They said on 2 or 3 occasions in that document something to the effect of, we're not telling the board how to rule. We're not saying you need to overturn your ruling. We're saying you need to make the ruling based on these factors, which the original board evidently didn't do in a way that they found acceptable. So I just wanted to point that out, that we're not suggesting that, well, what we're saying is, it's not predetermined just because it's been remanded that the decision has to change. It's just the basis of the decision is required to change, and that's all as I understand it. So Paul can help me, tell me whether I'm right about that.
Thank you, sir.
Thank you, sir. Anybody else? Go ahead, ma'am.
Alda Altizer, 14506 North Bel Air Drive, Southwest, Cumberland, Maryland. And I was here at the meeting in 15, okay? And I spoke at that meeting also. Today, I'd like to speak, number one, for Sue Dudley, who had to leave because she had an appointment. She has talked to she was a school nurse at Bel Air Elementary. And she is concerned because the elementary school sits at the base of Dan's Mountain. She has talked to Dr. Spiegel and Dr. Haslings from Grantsville, who has the wind farms there. And they
Ma'am, I'm sorry to interrupt you, but if I understand what you're going to be talking about is what doctors said about the wind farm, and I don't think there was any evidence of that in 2015.
No, not in 2015, you're correct.
So we can't talk about that today.
Okay, but there is something that you need to check into about that, because it would affect people today and at Bel Air Elementary. I live in Bel Air. My grandmother, and this is what I said at the 2015 meeting, grandmother and aunt both lived right outside of Marysdale, Pennsylvania. And the wind farms were right across the road and up on the hill from where they lived. And she said there was a constant noise that upset their lives at that time. very, very badly. And this is something probably you won't let me say either, but the bird life.
No, please.
The bird life.
Please don't.
The bird life, okay. Somebody needs to check into that because there's all kinds of studies being done, and they are saying that we have a whole lot less birds now than we did before. It could be because of the wind farms being put up across the
Did you
nation.
testify to this in 2015?
The birds, no.
Okay, then we cannot accept any testimony.
Okay.
Thank you,
very much.
ma'am.
But yeah, but it's something to think about. You've done all the studies, but nothing on that.
Thank you very much.
Okay.
Thank you very much. Ms. Tyler Getty, if you want to rebut.
I guess we should check. Is there anyone else? Oh,
I thought there was a gentleman that was,
oh, that's true. You're neutral, sir.
you neutral?
Would you?
Well, I said, that's what I said, I was neutral, because I just got a question.
A question for,
In other words, you're not going to allow me to speak.
no, sir.
Oh, no, sir. You can speak. I guess your questions are directed to who, I suppose I should ask. The board
My
can't,
questions are to the board.
we can't answer questions. I'd be happy to,
I can't answer questions.
yeah.
I'm just going to pose some questions of mine.
You mean in terms of things that we should be, that the
Well,
board should be thinking
Let me
about?
explain.
Okay.
My name's Robert Powell. Gentlemen, we're all familiar with one another because I sat in your place on this in 2015. Okay? So I'm not biased against the wind farm, but I do want to make several points that have come into question because I remember the testimony. And if I'm correct, the reason this was remanded, and you can answer me on this, Mr. Roses, is because the previous board did not consider this with the individual properties individually.
I believe that's correct. Correct generalization, yes.
It was, I can't remember what the statement was, but I can guarantee you that we considered each and every one of those wind turbines and where they were and what the variances were asked for. There were 7 turbines that did not meet the setbacks, 7 of the 17. And each one of them had anywhere from 100 feet inside the variance to somewhere about 500 or 600 feet was the differences between the variances between those 7 turbines. Now, the total was something like, I don't know what, 1,700 feet total.
I'm not aware of any mechanism by which essentially a judge can argue the correctness of his analysis or opinion. And I don't think it's appropriate for a former chairman of this Board of Appeals to explain his opinion, which has now been rejected by the Board of Special.
Okay.
Well, hold on a second, Mr. Powell. I'm sorry. Mr. Flynn, do you have an opinion you want to express? If not, I understand.
I think the gentleman is a citizen of the county and should be heard within reason. I'm not familiar with what legal authority Mr. Getty might be relying on for his objections, but
I think he's just relying on the general principle about judges testifying, but I think as long as Mr. Powell's talking about what he recalls the record showing, that's fine. I don't think he should get into the decision, why they made decisions that they did. But if he's talking about, I recall the setbacks being a total of 1,500 feet, I think that's acceptable. Do you understand what I'm saying, Mr. Powell?
I do, and I'm sorry to make this difficult. I was going to say, I'm not here to defend that board's decision, but I guess I am, because I know what we went through. And gentlemen, from what I understand, all 3 of you are new. All 4 of you are new. Faces have changed. So what has changed about this thing? I mean, there's no testimony on the part of the applicant that has changed. The only thing that has changed is the 4 different faces on the board. Now, I understand that, you know, you're coming under baptism under fire on this thing, because this is a difficult decision to make. And I served on that board 25 years. And let me tell you, everyone that I sat on was really difficult for me. Didn't make any difference whether it was some individual asking for 2 feet variance or whatever happened. But during my course on the board, I attended seminars and instructional stuff from the state of Maryland that told you how to address special exceptions and how to address variances. Special exceptions are really easy. I mean, all they have to do is ask for a special exception. And if it's on the list that particular project or that particular business can fit into that area, you allow the special exceptions. But variances, altogether different story. Variances, you don't allow variances unless they meet a whole lot of standards and a whole lot of stuff that you can prove that will allow that variance. Let me give you a couple examples of what I went through on the board in this.
Excuse me, sir, could you wrap it up in about 2 minutes?
Okay.
Thank you.
We had an individual that came before us several years ago. He had a lot. This was a homeowner. He had a lot that I wouldn't have paid $5 for, because that lot had a steep slope and everything. But this individual, he put the effort and the money into it. And he put land, he put fill, and he put retaining walls in and made, and built a beautiful home on there. He wanted to build a 3-car garage. So his property backed up to the property line, and then there was a blind alley behind it, and then properties behind that. But he couldn't meet the variance for this 3-car garage that he wanted, because he couldn't meet the setback. I think the setback was 8 foot, and he had it within a foot of his property line. So we turned him down the first time. So he went back, he kind of changed a few things to his garage, but he still wanted that 3-bay garage. He had some antique cars or something. So he got within, he reduced it to about 4 foot. We turned him down because of the variance. He couldn't have it. So he said, throwed up his hands, what can I do? So we said, well, you got a blind alley behind you. If you get that blind alley closed, that gives you more distance on your property line, and you can meet that. That individual went to the task, hiring a lawyer, getting the blind alley closed, and he met the setbacks. But that's an example of an individual that met the zoning laws. I mean, you're upholding the zoning laws in this county for everyone, not just certain individuals or not just whatever have you. So you got to remember that. And you're setting a precedence in this case whereby that you're going to allow 5 property owners to join hands and try to come together and get variances and sign off on it. That will be a precedence for the state of Maryland. And that's not a good idea, as the lawyer has brought up before.
Thank you, Mr. Powell.
If there's nobody else who wants to speak up in opposition? Mr. Gay?
I promise I won't take long. There are a couple observations I would make in terms of the information that's been presented to you. First, other than the information that I presented to you this morning about special exceptions, you haven't heard anything about a special exception. No one has challenged the evidence that was presented at the first hearing as being sufficient to sustain the finding that a special exception is warranted. The unrebutted testimony of Mr. Davis, Mr. Josephson, Mr. Brewer is that in this particular use under Schultz v. Pritz. This is a use that can, and I suggest based on all the evidence, and there's no argument to the contrary, should be approved. And the reason I bring that up first is that's the setting in which you then look at variance. If you assume for a minute that a special exception use, the wind farm is a permitted use with board approval. If there is board approval to that, we then have a permitted use without regard to limitations. But we need variances. We understand that. We came to the board and presented the evidence that we believe the Maryland courts look to and require. It is not an accident, as you might imagine, that I quoted to you not once but twice the determination by the Court of Special Appeals. Mr. Rosas actually quoted it, pointing out that there was sufficient evidence in the determination of the Court of Special Appeals that we had met the burden that the court imposed on us as to the variances. It is clear Windforce adduced evidence of several features of each of the co-applicants' property that suggests that separation and setback requirements operate differently on each of those properties than they operated on surrounding properties. Why is that important? It's important because that's the predicate for us standing here today to say to you, we understand the challenges that have been presented by the opponents. But I have to ask you to stop and think about what it is that's being asked. Mr. Flynn said, and I wrote down and quoted it, don't let the aggregate analysis hold here. And what he was talking about is that the testimony, the only testimony, again, the unrebutted testimony in this case is that when we looked at all of the factors I've given you on turbine by turbine, the factors that I gave you in the presentation this morning, when we look at all of those factors, it is not, for example, in Mr. Flynn's analysis, turbine 5 talking about wetlands, or it is not turbine 11 talking about the presence or absence of habitat, or how the beam paths go. It is an aggregate, and it is something that I pointed out in terms of the testimony of Mr. Brewer this morning. He says, while you can look at unique circumstances individually, it is important to note that from a planning, site planning, configuration standpoint, they must be considered in the aggregate and not individually, because each has an impact on the other. That's a quotation, a citation to transcript 182. But I have to also point out to you that one of the exhibits that Mr. Flynn presented to you, which is, I believe, 232, he was pointing it out for other reasons. But if you look at line 13 at page 192, in answer to a question that I had asked, specifically with respect to location of number 5 and the requested variances, what's the practical difficulty that generates the variance request? Mr. Brewer's answer to that was, so again, all of the different site constraints must be considered together in the aggregate. That is something that Mr. Brewer presented over and over and over again in the context of his analysis. And that leads us back to the challenge that was presented in terms of Mr. Flynn's argument about zoning merger. There is a misunderstanding of the position, not really a misunderstanding. We have claimed zoning merger, absolutely. And the court has said, we're not sure zoning merger applies. But I have to ask you to go back to the court's decision, because number one, it didn't say it didn't apply. But in every part of the court's analysis, it was not doing what Mr. Flynn suggested you had to do, and that is look at the Blau parcel, or look at the Lashbaugh parcel, or look at that's not how it was done. The court did its evaluation because there is an application for a variance, one. Now, in this case, that one application for a variance has 25 property owners and Dan's Mountain Windforce. It comprises 2,900 acres of land. When the court did its analysis, when the Court of Special Appeals said there is sufficient evidence to satisfy the variance standard, it wasn't looking at the Blau parcel or any of the other parcels individually. The court was, and Judge Friedman was, looking at the 2,900 acres because that's the applicant's property. It is not broken down parcel by parcel, and there is nothing in the Court of Special Appeals decision that says it has to be. Whether we call it merger, where we are merging the interests for purposes of it. We're not merging title, which is part of the analysis the court's done in other cases. But we are merging the interests of the individual landowners, 25 of them, together with Dan's Mountain to make an application for a zoning variance. One that the court found was legally sufficient, one that the court found satisfied the obligations that were imposed on the applicant, and one that I urge you is sufficient for you to find that in the aggregate, the unrebutted testimony of Mr. Brewer, the unrebutted testimony in this case, that the analysis you do is an aggregate analysis. That when you move turbines, there are all of these different features. When you look at that exhibit that I had made just to show how they all, what the confluence of that is, to show how limited the area is, that is what allows for relief under the ordinance, because that is unique. It is driven by the features on the land. It is driven by all of those features. We can't build windmills on part of the 2,900 acres because there were deep mines. We can't build windmills on a portion of the 2,900 because there were strip mines. They don't have to be depicted in total, because the testimony and the evidence adduced by the witnesses is that's what's there. You don't have to read Dr. Liu's report from WVU to understand that the mining part of it is a component. It's not the only component. And it doesn't have to apply to unit number 5 alone, because the location of the turbines, which now that we have, if we assume for a minute, we have a special exception use, we are now allowed to use our property for this purpose. Now we read relief in order to deal with the practical difficulty that comes from the limitations on design, from the slope of the property, which is all depicted on the exhibits, the beam paths, the wood rat habitat, the mountain, the rats, which they're not even sure they're there, but the habitat is there. All those things coalesce and aggregate to say, this is the best we can do with what we have. It's a permitted use, and as a permitted use, relief is reasonable because it addresses the practical difficulty of doing what we are permitted to do on our property. And we would ask that you make a decision, number one, finding that there is a basis for the special exception grant, and that each of the individual variance requests have been supported by substantial evidence, have satisfied the requirements of the court, take into consideration whether it is dicta or not, it is a statement made by this court in this case that objectively we have satisfied the obligations that exist in showing that we meet the criteria established by the court. In the first instance, that's a decision to be made by you. That is your jurisdiction. That's what the court is saying. But, law school professors always pointed out that you don't you don't jump ahead of dicta in your own case, because shame on you if you ignore, and that's directed at lawyers, not to you all, shame on the lawyer who ignores the dicta as to what it is he or she is supposed to do. In this particular case, the court is signaling, I think, through its use of dicta, not binding on you, that there is sufficient, legally sufficient evidence, because it says that. And then it says, in the first instance, it's a decision for you to make, and we would ask that you find that there is practical difficulty with respect to the variance applications that are before you, and that you allow the wind farm to be built. Thank you.
Does anybody have any questions for Mr. Getty? I have a few, if that's okay.
Go ahead.
I guess I'm going to talk about the Court of Special Appeals opinion first, then I want to ask you some questions about the record.
You've been waiting your entire life to do this.
So I get to question like Getty, yeah. You did say, you talked about legally sufficient, and the court, I agree, the court used that language, but that really means that we're the board to take the evidence, all the evidence most favorably to you, you've met your burden.
Absolutely.
Right. That's not.
It is not, I am not suggesting.
You've met your burden of persuasion.
I am not suggesting it carries the day. That's a decision for this board.
Okay. This has been a question that has been troubling me some about the decision, and so I'd like to talk about zoning merger. As Mr. Flynn and I discussed, that position has not been well received in the Court of Special Appeals.
It has not, but I can tell you from the argument with Judge Friedman, who wrote the opinion, and the concept that we advance as zoning merger comes from the Friends of, I'm not going to remember it. There's a cited case.
Friends of Ridge versus
Friends of the Ridge.
Yeah.
And that is a title merger. Okay, that is what Friends of the Ridge is all about. It's two lots adjoined, used together for a common purpose. And the question is, how does zoning apply to that once the lots have been combined for title purposes? Can it be further subdivided without addressing zoning? In our presentation to this board, in our presentation to the Circuit Court, in our presentation to the Court of Special Appeals, we have argued that zoning merger applies, but it's kind of like zoning merger light. It is the realization that you can have multiple applicants, you can have multiple property owners in a single land use. And when you do that, when you combine separate parcels and separate applicants into one proposed land use, you have, for the purpose of zoning, merged those properties in order for an analysis to be made of whether or not you satisfy the statute. Here's the example, and this is a real issue in the city of Cumberland. There's where the Kentucky Fried Chicken is, down on Virginia Avenue and Industrial Boulevard. The Kentucky Fried Chicken, for those of you who are old enough, that was Mr. Glick's used car lot. And so a portion of that property where the Kentucky Fried Chicken is located used to be a car lot. Another used to be a store. All of that is leased to Kentucky Fried Chicken for the purpose of that restaurant. So for the purpose of land use, when Kentucky Fried Chicken went to get a permit, they didn't go in and say, Mr. Glick, you have to make a permit application, so-and-so. They did it together. And that's all we're doing here, is saying there's a single use, multiple parcels. For purposes of analysis, we ignore the internal property lines because that's actually how the court looked at it.
Well, how does that square with what the court said in terms of properly identifying each property's unusual attributes?
The property is the 2,900 acres. It is a comparison, and that's what, if you think about it, that question I understand. But it is resolved when the court says at the end, that we have legally sufficient evidence to have done that. Because the court in its analysis, and Judge Friedman, when he wrote the decision, is still looking at our 2,900 acres as one applicant for a land use permit.
Do you think that ultimately makes a difference to your application, whether the board accepts your zoning merger argument?
No, I don't think it dictates the outcome, because, again, look at what we have. We have an application. There are a number of applicants, but there is one application. So the analysis, whether you talk about it as having been merged, it's not merged for title purposes. Each of these are separate parcels. Each person still owns their property. But as a land use, everyone has come together. So whether you call it merger or acknowledge that it's a single land use, it really doesn't matter, because the burden doesn't break out the way Mr. Flynn has suggested, where I have to take each of the applicant's properties, because the court specifically said you don't compare one applicant's property to another co-applicant's property when it rejected the earlier board's decision.
But if the board were to say, Mr. Getty, out of the evidence you've presented, can the board pull out, using Mr. Flynn's omelet example, can we pull out the egg of the Cessnick property based on the evidence you've presented to us, for example?
But if you do that, if you are pulling out the egg as the Cessnick property, you're doing exactly what the Court of Special Appeals rejected in this case, because that's not where the judgment goes. The judgment goes from the location of the tower that impacts the Cessnick property. And the tower is part of this joint application. It's on the applicant's property. That's, you can't, I urge you, you can't go back into looking at individual properties and unscrambling Mr. Flynn's omelet by looking at individual properties. You have to look at it in the aggregate, because it is the applicant's property.
And I guess a follow-up question to that, which goes back to the evidence, Mr. Flynn's argument, one of Mr. Flynn's arguments, is that the issues that afflict these properties are not unique to those properties, in that they are endemic to the top of Dan's Mountain, if I can use his phrase.
And there is no evidence that that's true. There is no evidence in this record that any of these conditions exist on any other property. The evidence is it exists on this property.
Gentlemen, any other questions?
Thank you, Mr. Kenny.
Thank you, Mr. Getty. Do you want to take a break for a minute, Mr. Walters?
Yeah, we'll take about 2 o'clock right now. We'll recess to about 2:10.
Where's that document I gave?
Oh, I'm so sorry. Yeah, I just needed to look at that.
Yeah, no, I just.
Sure, I got my stuff okay. Yeah, I'm fine. Okay. The hearing's back in session. Mr. Dickerhoop, you have a question for Mr.
Yes, I have a question, Mr. Getty, please.
Mr. Getty, could you please?
Mr. Getty, based on your last comment, you seem to suggest the board, in using your words, consider the variance in aggregate.
That's correct.
Reading from the Court of Appeals, I'm going to quote, "Thus, we hold that the board should have reviewed the requests under the more lenient, quote-unquote, practical difficulty standard as outlined in Rottwein. On remand," and I'm going to emphasize here, "the board should consider each of the variance applications," that's plural, "using that legal standard." Are you suggesting that we disregard the board's charge?
Oh, absolutely not.
The court's charge, excuse me?
No, in fact, if you look at the one document that I gave you, which is an aggregate of all of the different tower sites with citations, that's my realization that you have to do them individually. I am not asking you to aggregate a decision on the variances. I am asking you to consider the testimony from Mr. Brewer that the factors aggregate that relate to those specific variances.
I understand. Thank you.
Any other questions?
No, that was good.
I have a question for just a quick question for Mr. Flynn. Mr. Flynn, as Mr. Getty pointed out, there hasn't been a lot of discussions about the exception issue. Under the Pritz, would you concede that the Pritz test has been met for the exceptions purpose, for the exceptions issue?
No, sir.
Tell me why.
There were a whole box of records, of public testimony, letters submitted to the prior board, comments given verbally before the prior board, explaining in detail and including demographic information and statistical information concerning the population of the county and the concentration of that population in the area of these proposed turbines, demonstrating how this project would have a greater adverse impact in this location than it would in a different location. Frankly, the way the board handled this in 2015 certainly made more sense to me than what Mr. Getty is suggesting. He's suggesting that the special exception comes first and the variance is second. In 2015, I believe it was done the opposite way, which makes more sense to me. I don't know why you would address a special exception if the variances upon which it's conditioned are not granted. So to me, that would be putting the cart before the horse, doing the special exception first. I didn't address it in my argument because I just don't see how we get there. I don't see how the variances are granted.
Okay, thank you. Well, I think that concludes this.
Concludes the hearing portion.
My understanding, ladies and gentlemen, is that the board has decided that it wishes to take an opportunity to look at all the material. Well, let me back up a second. Deliberations of the board are open to the public. So before the board makes a decision, the members will deliberate in open here. However, there's a lot of material to look at, and the lawyers have mentioned several records that I think the board would like to go back and look at. So the board intends to reconvene next Wednesday at 8:30. In that week, board members will be looking at the testimony, the documents and whatnot, and will come back and actually deliberate and reach decision next Wednesday at 8:30. Is that correct, Mr. Walters?
That is correct. Thank you. That concludes the hearing.
Thank you.
Oh, wait.
Anybody who spoke, make sure that you signed up, name, address, mailing address. You have that.
Did everyone hear? If you spoke, please make sure that you signed up and that your name and address are on there. All right, now, before we lose a whole bunch of exhibits, Mr. Squires, let's make sure we get you the right things here.
Two I'm missing.
I think this is an original, 236.